in response to the application, we are opposed to that application on the basis that the same lacks in legal merits. To have the same warrant. The court, being a neutral arbiter, ought not to be seen as to be facilitating the prosecution or the investigations in their endeavors. And as such, Your Honor, that application is not premised on any legal basis. The Criminal Procedure Code has no room for such an application. It's the thinking of the defense, Your Honor, if we are right, that this is part and parcel of a trial. The investigation can still continue as it has been, with the subjects before you being free citizens, without being under the yoke of any compelling court orders. To that extent, Your Honor, the prosecution has not indicated to you whether there has been any interference with the investigations. And the purpose of that application was to restrain any interference. In the absence of such, Your Honor, this application has no case. We urge you to dismiss it and set the subject free as and when the prosecution is ready. The DCI knows what they're supposed to do. These are Kenyan subjects. They are freedom fighters. They are liberators. And they believe in the cause of law, or in the rule of law, which they are fighting to have the same. When we shall be calling for accountability on why these subjects are before you, Your Honor, where shall we place these proceedings? Noting that Article 10 calls all of us and enjoin all of us to have accountability to the rule of law. We urge you to decline the invitation, to be seen as though the court is aiding the prosecution in their cause. Mr. Murek will request the objection.
Your Honor, in our constitution, the principle of the presumption of innocence still reigns supreme, regardless of whatever investigation processes the DCI may be undertaking. Your Honor, there is a worrying trend in this country whereby state actors, the DCI and the prosecution, seek to bring citizens of this country before courts without having conducted their investigation, and then seek the court to rubber stamp that physicality of putting the cart before the horse. And there is nothing at all that prevents the closure of this miscellaneous file at this point if the prosecution have not been able to come up with sufficient material to charge the person before you. And they can continue with the investigation when they have evidence to sustain a charge. We can meet again before you or before any other court under those circumstances. Your Honor, however, this application to continue holding these subjects under this yoke that my senior has spoken about is nothing but a disguised attempt to intimidate them, to silence them, and to continue drilling and monitoring them, limiting their liberties as Kenyans unlawfully. And what the prosecution is asking you to do is to rubber stamp that. And we strongly invite you to decline that and to dismiss that application and to order that the three be set free. They have been complying with the orders of this court to the letter. You know, their gadgets are still held by the DCI. They have been reporting the police station twice a week without fail at a considerable cost to them. When I was conferring with my clients earlier before court, and we were estimating that the cost of reporting to that police station twice a week has run to more than 20,000 shillings. And Donna, these are not men of means, as you can see, they are ordinary Kenyans. And for that reason, we strongly invite the court to decline the prosecution's application and to set them free. When the prosecution comes up with evidence of any nature, if they can, then we shall be back here. I invite my colleague Wanjera Maina.
One minute before Wanjera addresses him. The prosecution has confirmed to you that they are 70% done. That means, Your Honor, a prima facie case must have been laid out as to whether to charge or not to charge. Yes, that is, you know, I had not finished. It's only that I saw that you're not taking back, but then I want to take your attention. I indicated, Your Honor, 70% has been confirmed by the prosecution to have been complete of the investigations. This court bears me witness that the High Court has confirmed that investigation is an ongoing process. So why are they not utilizing that 70% in their favor, if at all there is evidence? And then that percent can be covered when the legal process has commenced. 30%, Your Honor, is something that the High Court was speaking to, that it can be covered while the trial is still on, if the intended is to ever charge them. That's all.
Yes. And those 21 days have already lapsed, Your Honor. This is the time they sought, and that 21 days has already lapsed. So it cannot be that 70% was done in 21 days, but they seek to do 30% in 30 days. It does not speak even, and it does not even hold up to common sense. It cannot be that way. Your Honor, a request to extend time should at least come on oath, because this is serious. They are seeking to have our clients